कोई तो देख
5 on 5th.
on
On 5th.
okay
Okay.
for orders.
नहीं फिफ्थ को on the same heading ही रहेगा क्योंकि ये लोग तो उस दिन बहस करेंगे ना आप लोग फाइनली
जी हाँ फाइनली बात करेंगे because he is saying that the years of
हाँ
advisory is
on.
already
Okay.
so he may file a petition for deletion or not
Yes.
if even then that has
चलिए ये judgment मिलेगा
From date list for judgment item 1, the look period 2429 of 2010.
This petition is dismissed. ये कार्टेज पता नहीं कहाँ का है ऑलमोस्ट खत्म हो रहा है इसको चेंज करना Yes, Mr.
If
Ramesh.
Kashmir
You have
has
taken
taken
instructions?
instruction, he is ready to file a joint compromise petition. On Tuesday, he can come and file it, and let it be on Thursday, can be disposed of finally.
Okay. Where is Mr. Simon? You please call him. I'll just.
I just call.
From
Joint compromise के लिए बात हुई थी first half में.
Yes.
Learned Council for the parties are present. The Learned Council for the appellant has submitted that so far as the refund of rupees 25 lakhs with interest is concerned, the same is based on materials on record and he does not have much grievance. His client was also present in the court. He submits that so far as damages awarded by the learned court is concerned, the same was neither based on any pleading with respect to the quantum of damages, nor was based on any evidence. The Learned Counsel appearing on behalf of the respondents has submitted that he has taken instructions from his client and he is ready for a compromise. Upon this, the Learned Counsel for the parties have submitted that they shall file a joint compromise petition latest by Tuesday. Post this case on Thursday in the supplementary cause list.
appearance दीजिए
ये serial number कौन सा बताइए?
Supplementary case.
serial 2, 2nd April 390 of 2017.
ये कौन सा serial number?
Supplementary list serial number 6.
Supplementary का serial number 6. Correspondent नहीं आ रहे हैं? ठीक है. उनका नाम
उनको मैं खबर कर सकता हूँ
हाँ कर दीजिए.
उनको
उनके absence में order करना
हाँ नहीं हम बुला हम खुद फ्रेंकली हमारा फ्रेंकली
उनको आने दीजिए.
हाँ
वो जजमेंट दिए हैं. Second appeal, यही वाला.
Yes, Mr. क्या कर सी टेलिंग कि आप कंटिन्यू कीजिए सर आ जाएंगे
हो गया आर्गुमेंट इनका हो चुका
Lordship is on like say Lordship. In court number 3 Lordship.
कितनी देर में लगते
पास
हैं
ओवर कर दिया तो Lordship will just include.
टाइम बताइए ना कितना बजे
Lordship.
क्योंकि ये भी बहुत बिजी रहते हैं
Lordship 3 PM. 3 बजे के लिए fix कर दिया.
उनको बता दीजिए हम लोग क्या सोच रहे हैं
हाँ बता दें
3 बजे
Obliged.
For hearing under order 41 rule 11 item 6 second appeal 142 of 2019.
Are you for the respondent?
Lordship, state responding. DC has Alibag and CO each other. Land Lordship, where miserable land and
अभी सेकेंड अपील एडमिट नहीं हुई
yes, Lordship.
Where is the appellant? There are concurrent findings. देखिए
Concurrent findings Lordship. And private parties also there.
देखिए सेकेंड अपील नंबर 142 of 2019. Nobody appears on behalf of the appellant. इसको पास ओवर करते हैं नहीं तो आज DSD कर ही देंगे लास्ट चांस हो चुका है इसमें जिस केस में लास्ट चांस हो चुका है द केस इज टू बी डिसमिस्ड राइट मिस्टर विनोद कुमार दुबे खबर मिस्टर अरविंद प्रजापति मिस्टर नवीन कुमार 3 वकील हैं कोई भी नहीं अपीयर होगा कार्ड इसका DFD होना तय
आप
आगे मिस्टर शैलेंद्र कुमार तिवारी आप आए हैं सब्सटैंटिव क्वेश्चन नंबर 1 के लिए आपको क्या बोलना है
Item 2 second appeal 390 of 2017.
इसको कब पे रखिएगा क्या
हम तो आपके बिना ही ऑर्डर लिखा रहे थे आपको इनविटेशन कार्ड भेजे 3 बार आपका नाम फ्लैश किए आपको बुलाए हैं अब आपको कल पे रखना है बहुत सिंपल सी बात है ठीक है तो हम रख देते हैं ऐसी बात नहीं है पहला सब्सटेंशियल क्वेश्चन ऑफ लॉ में यही है कि कोई रीजन नहीं दिया है कि बाय द कोर्ट इज डिफरिंग फ्रॉम द रीजनिंग गिवन बाय द लर्नड ट्रायल कोर्ट का जजमेंट काफ़ी एलाबोरेट है नाउ इसी पर पहला क्वेश्चन ऑफ लॉ फेल है पॉइंट ऑफ डिटर्मिनेशन भी नहीं बनाया आपने रीजनिंग नहीं मीट किया है, पॉइंट ऑफ डिटर्मिनेशन नहीं किया है, इनका कहना है कि ओरल एविडेंस को कंसिडर ही नहीं किया। देन अंडर सच सर्कमस्टांसेस ऑर्डर 41 रूल 31 का कंप्लायंस नहीं होने के कारण द मैटर इज टू बी रिमांडेड, एंड इफ द मैटर इज टू बी रिमांडेड देन रेस्ट ऑफ द इश्यूज विल बी कंसिडर्ड बाय द एपेलेट कोर्ट ओनली, फर्स्ट एपेलेट कोर्ट। यहाँ पे क्या ही डिसाइड किया?
जो कंट्राडिक्टरी जो फाइंडिंग्स होगा, अपीलेट कोर्ट का जिस पॉइंट पे कंट्राडिक्शन होगा उसी पॉइंट को सिर्फ हम लोग यहाँ आर्गुमेंट करेंगे उसमें।
ठीक है ना?
इस पे हम दो तीन पॉइंट जो रेट किया गया, इस पे हम अपना कॉन्साइज्ड आर्गुमेंट कल कर
नहीं
दें।
नहीं, कल नहीं, आप पीछे बैठ जाइए जितना, और ये जजमेंट दे दीजिए, इस जजमेंट को पढ़िए और बैठ के बताइए क्या। हैव अ लुक एट दिस। चलिए नेक्स्ट पेज।
Item 7, second
हाँ वो हो
will
गया।
जी सर, मंगलवार
थर्सडे मंगलवार को जॉइंट कॉम्प्रोमाइज फाइल करिए, थर्सडे को रहेगा।
सॉरी हम नॉट
आपका सबमिशन लिखा दिए हैं
जी
कि वो 50 लाख का कोई मतलब 25 लाख पर
पच्चीस।
आपको मतलब 25 लाख पर आपको कोई रिवांस नहीं है विद इंटरेस्ट, और 50 लाख वाला जो है
उसमें हम
ठीक है।
वेरी सॉरी
Item 7, second.
6 नंबर पहले ऊपर
Item 7, second appeal 147 of 2019.
अब बताइए।
May please. Lord, the appellants are the plaintiff, and there is concurrent finding of both of the courts. This suit has been filed by the plaintiff for declaration of their right, title, interest, and possession. Since the land belongs to the ancestor of the plaintiffs, but the father of the plaintiffs has executed two conditional mortgage deed in favor of the ancestor of the defendants.
जस्ट अ मोमेंट, देयर आर कॉन्करेंट फाइंडिंग्स, पहले सब्सटेंशियल क्वेश्चन ऑफ लॉ दिखाइए, उसके बाद से
Obliged. Page 5, your lordship.
यस आई एम देयर।
Ma'am, whether the learned trial court as well as appellate court can decide this suit without considering the section 46 of the Chota Nagpur Tenancy Act, which debar the mortgage by conditional sale. Second is, whether the findings of the lower appellate court is perverse, having not considered that Exhibit B is a registered deed of by will wafa, cannot sustain in view of section 46 of the Chota Nagpur Tenancy Act.
ये बाइबिल वफा क्या होता है?
बाइबिल वफा उसका नाम दिया गया है, जो रजिस्टर्ड डीड का लोकल नेम दिया गया है, कुटी रांची डिस्ट्रिक्ट कुटी
रजिस्टर्ड डीड।
हाँ, लेकिन ये कंडीशनल मॉर्गेज डीड है एग्जिबिट बी, जिसके आधार पर लर्नेड ट्रायल कोर्ट एज वेल एज द अपीलेट कोर्ट डिक्लेयर द राइट, टाइटल, इंटरेस्ट एंड पोजीशन इन
ये
फेवर ऑफ
1974 पटना एंड 1936 पटना क्या है?
Yes, my lord, it is, my lord, if the issue has not been framed, my lord, issue has not been framed by the trial court, since plaintiff having no knowledge in respect of the exhibit B, and the written statement has been filed in which it has also not been indicated, and in the course of trial, my lord, the same has been exhibited. So there is no issue by the trial court, and this point has been framed by the in the appellate court, my lord, and under 96 of the CPC, the appellate court may consider the fact as well as the law, but the same has not been considered. So the declaration of the right, title, interest and possession, your lordship, on the basis of the exhibit B, which is the conditional mortgage
This
deed.
exhibit B was exhibited for the first time before the appellate court.
No, before the trial court.
So what is the story that you are telling about this? These two, why these two judgments are relevant? 74 Patna and 36 Patna. Where are these two judgments?
My lord, since issue has not been framed, my lord,
Which issue has not been framed?
in respect of the exhibit B, that whether this is the document which has been executed as per the section 23 of the Contract Act. Section 23 Contract Act says.
Issue फिर बाद में appellate court has framed this issue.
Well,
Show me these judgments. आपकी बात नहीं समझ रहा।
जी हुजूर,
Judgment दीजिए।
मैं इसका जजमेंट हम नहीं लाए.
नहीं लाए तो क्यों आप सब्सटेंशियल क्वेश्चन ऑफ नॉन लिखे? गिव अप दिस सब्सटेंशियल क्वेश्चन. इसका जजमेंट नहीं लेके आए, उसका हम लोग क्या कर सकते हैं?
तो ये दो हमारा जो है उस पर हमारा जजमेंट है, जो सेक्शन 46 पर.
बताइए.
मैं
Where is the findings of the learned
finding
court?
of your lordship.
What were the issues before the learned court?
Issue was before the learned trial court is below page 11. Page 11 में
Suit was for declaration of title
my lord, right title, interest and possession.
and confirmation of possession.
Confirmation also. Issue is in page 11 of my petition.
What was the case of the defendant? You were claiming on what basis?
Defendant is saying,
About you. You are the plaintiff.
yes,
What was your case?
my case was is that the land belongs to the ancestor of the plaintiffs, and the defendants disturb the peaceful possession of the plaintiffs, and for which 107 proceeding has been initiated, and thereafter the suit has been filed, and the plaintiffs said that 2 conditional mortgage deed has been executed by the ancestor of the plaintiffs with condition that he will refund the money, then the sale deed shall be returned, and it has been returned. But after filing the suit, the written statement has been filed without disclosing the another conditional deed, mortgage deed is also there of 1991, but the same has not been disclosed in the written statement. That is, kindly peruse my lord page 11, paragraph
You
10.
read para 10 first.
Yes,
According
ma'am.
to the written
Ma'am.
statement.
According to the written statement filed on behalf of the defendants number 1 to 5, in fact, Etwa Swasi, father of plaintiffs, transferred the land of village Guni appertains to Khata number 13, plot number 14 and 15, area 22, 1/2 decimals out of 45 decimals and 30 decimals out of 26 decimals, wide registered deed conditional mortgage to Turku Mahato, father of the defendants, and since then these defendants are in actual physical possession of aforesaid land, which is more than 20 years, and thus defendants have acquired right, title and interest by adverse possession. Apart from aforesaid fact, the defendants also contested the suit on the ground that the suit is barred by law of limitation, and the plaintiffs have no valid cause of action, as also that the suit is false, fabricated and vexatious and liable to be dismissed. My humble submission is below, there is no indication in respect of the Exhibit B in the written statement. And due to that reason, no issue.
Exhibit B is dated.
Exhibit B is dated, your lordship. Exhibit B is 19/4/1991. And due to that reason, your lordship, the issue has not been framed in paragraph 11. That is the issue, your lordship. There is no issue in respect of Exhibit B. First issue is whether the suit is maintainable in its present form, whether the suit is barred by law of limitation.
There is already a mention of one conditional mortgage deed. What is the deed number? What is the date of this deed?
1991, madam?
In the written statement, there is a mention of conditional mortgage.
but
Wide registered deed conditional mortgage to
तुर्कुमा
हाँ इसका क्या डेट है?
इसका दो पहले कंडीशनल मॉर्गेज डीड हुआ था, जिसका चर्चा हम किए हुए हैं, अपने प्लेंटिफ की तुर्कु महतो को ट्रांसफर किए थे, एंड द मनी हैज बीन रिटर्न बाय द फादर ऑफ द प्लेंटिफ्स, and the original sale deed has also been returned by the ancestor of the defendants. So the sale deed dated 19/4/1991 was not within the knowledge of the plaintiffs.
No, but it is mentioned here.
My lord, only registered deed has been mentioned.
Yes.
No,
Further detail has not been mentioned.
not
But he is
mentioned, and due
mentioning
to that reason, the issue have not been framed on that point, my lord. Whether on the said deed, whether the right title
Issue number
interest.
4.
Yes, my lord. Issue number 4. Whether the mortgage discharge after the entire payment have been made by the mortgager to the mortgagee within the stipulated time.
Exhibit B is already there.
This issue is in respect of Exhibit 6, 5 and 6, my lord. Those conditional mortgage deed which were executed, money has been paid and original sale deed has been returned. And the right title, interest and possession partly allowed in favor of the defendants on the basis of the Exhibit B, your lordship, and that sale deed is not valid as per section 46 of the Chota Nagpur Tenancy Act, my lord, since without the permission of the Deputy Commissioner, it has been executed.
We do not know. There is nothing mentioned about the CNT. We do not know whether this land is covered by
Yes,
CNT or not.
my lord rightly said, my lord.
So,
In the appeal, my lord, it has been raised by the appeal.
raised ऐसे थोड़ी होता है बिना plain written statement के. You will raise it.
My lord, the law point can be
What
raised.
law point? It is not a law point. It's a matter of fact. Whether the property is governed by CNT Act or not. What is the status of the
Well,
parties? Whether they belong to any SC, ST, OBC, under which category they are belonging.
My lord, they are belonging ST category.
How do you know?
Yes, my lord, that can
बिना
be.
foundational pleading के ऐसा नहीं होता है.
Can be
आपके
seen, my lord,
personal knowledge से
paragraph 4,
cases
my
नहीं
lord.
चलते.
Paragraph 4, my lord.
Paragraph 4 of what?
4 of the judgment, your lords.
Which judgment?
Trial court.
Yes.
For the page 9, my lord.
You are the plaintiff?
Plaintiffs, my lord. And they are the tribal, my lord.
No. That is, I just want to know
My lord.
that you say that there is evidence that you are the ST category.
My lord.
You belong to ST.
My lord.
Where is it?
My lord.
Where is it? Where is it mentioned that you belong to ST category? नाम रख देने से नहीं हो जाता है. सब मांझी बोलने से ST नहीं हो जाएगा. नहीं है, कुछ नहीं है. आगे बताइए क्या बोलना है. The suit was partly decreed in your favor.
Yes, well, partly decreed since the conditional mortgage deed has been returned by the ancestor of the plaintiffs and partly decreed in favor of the defendants on the basis of the Exhibit B. So my humble submission is, my lord, before the appellate court, this plea has been raised for which, my lord, kindly see, my lord, the judgment of the appellate court, your lordship.
First, show me the finding of the letter.
Ma'am.
Partly decreed with respect to
My lord.
Schedule
Finding part is, my lord,
A property.
page 22, your lordship, paragraph 8. This is case as per memo of appeal, it appears that.
That's it. Para 17, then para 19 of the trial court judgment. What happened in the appellate court?
Appellate court, my lord, page 22, your lordship. Finding is in paragraph 8, page 22, internal page 4.
Yes.
In this case, as per memo of appeal, it appears that appellants plaintiffs has aggrieved and dissatisfied with the judgment and decree passed by the learned court below. This appeal has been preferred on the following grounds: that the judgment and decree passed by the learned court below is contrary to law, facts of the case, and evidence on record. It is further submitted that the learned court below has gravely erred in relying upon the oral and documentary evidence adduced on behalf of the defendants respondents, and has also misconstrued and misinterpreted the deeds of mortgage dated 19/4/81 Exhibit B and had failed to consider that the plaintiffs' appellants are the members of scheduled caste and the land in dispute could not have been given in mortgage by conditional sale, that is White Exhibit B, because the same was in contravention of the provisions of Section 46 of the CNT Act and was ab initio void in the eye of law. And the defendants did not acquire any right on the basis of the alleged deed. It is further submitted that the learned court below has failed to consider that a member of scheduled caste community can transfer his rayati land by sale, gift, mortgage, and otherwise is a member of scheduled caste community, and that also with the permission of the deputy commissioner. And Exhibit B is also void according to the provision contained in Section 23 of the Indian Contract Act. The learned court below has gravely erred in deciding issue number 4 in part in favor of the plaintiff, while deciding the issue number 2 that the defendants have proved their right, title, interest, and possession with respect to 22 1 by 2 decimal out of 45 decimals of plot number 48 under khata number 30 by way of adverse possession, as well as in the light of registered deed of conditional mortgage within bracket Exhibit B. The learned court below has failed to consider that in case of acquiring title by adverse possession, there must be pleading and proof of hostile title to the knowledge of true owners. There was neither any pleading nor any evidence on behalf of defendants regarding claim of hostile title, and as such, the learned court below had no option but to hold that the plaintiff are entitled to a decree with respect to 22 decimal out of plot number 48 of khata number 13. Plaintiff's appellant have prayed to set aside the judgment and decree passed by the learned court below and the PPL. In other side, it is a specific case of defendant respondent that the father of plaintiff, namely Etwa Swasi, had transferred the land of village Guni pertaining to khata number 13 in plot number 48, area 22, 1 by 2 decimal out of 45 decimals, and in plot number 50, area 13 decimal out of 26, by virtue of registered deed of conditional mortgage, that is by registered by Bill Wafa on 19/4/91 for the period of 7 years, it should be 5 years now. That is from Samvat 2048 to Samvat 2054, corresponding to year 1991 to 1998, in favor of Turku Mahto, father of these defendants, respondents, and had handed over actual physical possession of the aforesaid land to Turku Mahto. It is further case of respondents defendant that as per said by Bill Wafa and dated 19/4/91, said Etwa Swasi, that is mortgager or his successor in interest, has to pay back or return the said amount of rupees 5,000 to the mortgagee, that is to Sri Turku Mahto or his successor in interest within the stipulated period of 7 years, that is till Samvat 2054, corresponding to year 1998, to redeem the mortgage property in favor of mortgager or his successor in interest. Otherwise, the mortgage property has to be tuned into a sale, and the mortgage has acquired valid right, title, interest over the mortgaged land, as if the said land is his purchased land. It is further case of respondent since after execution of such by Bill Wafa, that is conditional mortgage dated 19/4/91, neither the mortgager Etwa Swasi nor his successor in interest, that is the plaintiff appellants, has returned such money of rupees 5,000 to the mortgagee Turku Mahto or his successor in interest, that is defendant respondents, till the specified period or even till the filing of suit. Hence, after the lapse of contingent period of such mortgage, the same has turned into the sale, and thereby these defendants respondents had acquired valid right, title, and interest, as well as possession over the land as such mentioned in the aforesaid mortgage dated 19/4/91, and
Essay
thereby
number 147 of 2019. Or the learned counsel appearing on behalf of the appellants. This appeal has been filed. Against the judgment dated 17/1/2019 and decree sealed and signed on 25/1/2019 in civil appeal within bracket title appeal bracket rules number 18 of 2013, passed by the learned district and additional session judge 1 Kuti, whereby the appeal filed by the plaintiffs has been dismissed. The title suit was decided by judgment dated judgment dated 31/1/2013 in title suit number 14 of 2011, decree sealed and signed on 6/2/2013, passed by Learned Munshi Kudri, whereby the suit was dismissed. The Learned Counsel for the appellant, by assailing the impugned judgments, has submitted that there was no specific mention with respect to the deed of mortgage dated 19/4/1981, deed of conditional mortgage dated 19/4/1981 within bracket Exhibit B, in the written statement of the defendants, and accordingly no specific issue was framed in connection with the same. He has submitted that the suit was decreed only partly in favor of the plaintiffs, and the property covered by Exhibit B and relief in connection with property covered by Exhibit B was not granted. The Learned Counsel has submitted that at the appellate stage, a specific plea was raised that the plaintiffs belong to scheduled tribe category and mortgage deed by conditional sale is barred under the provisions of section 46 of the Chotanagpur Tenancy Act, and therefore therefore the property covered by Exhibit B was also required to be decreed in favor of the plaintiffs/appellants. The Learned Counsel has submitted that the mortgage by conditional sale is popularly known as deed of buy by wafa, BAI by bill, BIL WAFA. After hearing the Learned Counsel appearing on behalf of the appellant, this court finds that, as recorded in the judgment of the Learned Trial Court, the suit was filed seeking declaration of right, title and interest, and also confirmation of possession of the plaintiff over the suit land, which the plaintiffs claimed to have been recorded in the name of their ancestors. The genealogy of the plaintiffs was given. And it was their case that Etwa Swasi, father of the plaintiff, number 1, had given the suit land to Tutu Mehto, father of the defendants, by a registered deed of conditional mortgage dated 24/4/1981 and 3/6/1983 for a fixed period, and all the said mortgage were discharged after the entire payment was made by the mortgager to Tutu Mehto, father of the defendants within the stipulated time given in the deeds, which was apparent from the endorsement on the backside of the deed, and after that mortgage handed over the original deeds. And since then the plaintiffs were in possession of the suit property and paying rent to the state. It was their further case that the cause of action for the suit arose when a proceeding under section 107 of CRPC was dropped and the defendants remained interested in denying the plaintiffs title and possession over the suit land on several successive dates, lastly on 28/11/2011. The written statement was filed by the defendants mentioning that the father of the plaintiff the father of Edva Swasi had transferred portion of the suit land by registered conditional mortgage to Turku Mehto, father of the defendants, and since then these defendants were in actual physical possession of the land and such deed was executed more than 20 years. It was also asserted that they also claimed adverse possession over the suit property. The trial court framed as many as 6 issues. However, by considering issue number 2, however, the learned trial court considered the legality and validity of Exhibit B based on the materials on record and held that the plaintiffs failed to prove that the registered deed of conditional mortgage Exhibit B is false and that at the time of execution of the same, that is on 19/4/91, the mortgager Edva Swasi was not alive. The trial court also held that the defendants had not claimed any title and interest with regard to rest of the suit property. Consequently, while deciding issue number 4, it was partly decided in favor of the plaintiffs with regard to the part of the suit land pertaining to part of the suit land in favor of the plaintiffs, excluding the property covered by registered conditional mortgage Exhibit B. And so far as the property covered by registered mortgage Exhibit B is concerned, the same was decided in favor of the defendants. The suit was partly decreed. The perusal of the trial court judgment does not reveal that the plaintiffs ever claimed that they belong to scheduled tribe community, nor they claimed that the property was covered under the provisions of the Tobacco Tenancy Act. Rather, it was their specific case that the liability under the earlier registered deeds of conditional mortgage dated 4/1981 and 3/6/1983 was duly discharged. However, when the learned trial court refused to pass decree in their favor with respect to the property covered by Exhibit B, at the appellate stage, the plaintiffs for the first time claimed that they belong to scheduled tribe category, and that the transaction in connection with registered mortgage deed dated 19/4/1981 was hit by Section 46 of Chotanagpur Tenancy Act. The learned counsel, the learned appellate court has recorded the finding that Exhibit B, being a registered document, there is a presumptive value with regard to its valid execution, and the party questioning the genuineness of transaction has to show that in law it was invalid. The plaintiffs, it was for the plaintiffs to establish that the said registered deed of conditional mortgage within bracket by bill Wafa by Exhibit B was false document, and same was never executed by Etwa Swasi. But the plaintiffs failed to do so. With regard to the challenge by the plaintiffs on the ground of any bar for transfer under Section 46 of the Nagpur Tenancy Act, it was observed that no such plea was ever taken. And the learned court has said that the plaintiffs in their plaint, either on the ground, have not taken any such plea or bar under Section 46 of the Chotanagpur Tenancy Act, nor the same was challenged in the suit by way of redemption of mortgage. The learned appellate court finally held that the appellate court finally upheld the findings of the learned trial court and dismissed the appeal. This court is of the considered view that no such plea with regard to this court finds that both the learned courts have considered the materials on record, and the learned appellate court has also considered the plea which has been raised by the appellant for the first time before the appellate court with regard to bar under Section 46 of the Nagpur Tenancy Act, and that the appellants belong to the scheduled tribe category, and has refused to entertain such a plea, and has also observed that there is a presumption in connection with the execution of registered deed, and the challenge of Exhibit B on other grounds, like it was never executed by Etwa Swasi, etc., was rejected. There are concurrent findings recorded by both the courts. This court finds no question of law, much less a substantial question of law involved. Accordingly, this appeal is hereby dismissed.
Delete.
देखिए
First one is 92, second is 390.
There are 4 substantial questions made in this case also, for consideration also. Kindly have a look at the substantial question number A. That whether the findings of the learned court of appellate below on exhibit A.
Exhibit 4 होगा वो. Exhibit 4 होगा. This is a typographical error. Do you agree or you don't agree?
ये उसी को हम बोल रहे थे कि error, that is error.
ठीक. वो हम लोग देखेंगे.
सेकेंड जो बना हुआ बी, सेम चीज उसी के बारे में एग्जिबिट 4 के बारे में लिखा हुआ है. मीनिंग अगर उसको करेक्ट कर लिया जाए तो ए एंड बी दोनों सब्सटेंशियल क्वेश्चन एग्जिबिट 4 पर है. Learned court of the appellate below has applied correct principle of law and was justified in the relying upon the exhibit 4. A true copy of the partition deed and also has further misconstrued with the admissibility of the said document of the taking secondary evidence when in absence of a foundation fact under section 65 of the evidence. This is the substantial question. And whether the first appellate court is discussed this exhibit 4 with true perspective or not, that is here for consideration also. Kindly have a look. Paragraph 13 of the impugned judgment. First appellate court judgment also.
First we will see the trial court judgment and then the first. First we will see the trial court judgment, then the first appeal.
नहीं, यहाँ तो फर्स्ट अपील को ही चैलेंज किया गया है ना. उसके बाद उसी को देख लेंगे एग्जिबिट 4 पे. दोनों का एग्जिबिट 4 पे क्या फाइंडिंग्स है, दोनों का फाइंडिंग्स हम देख लेंगे, whether that is true or not.
So you want to place the trial court's judgment later? आपको जब मन हो, जैसा सीक्वेंस आपको समझ. You want to place.
दोनों को हम कंपेयर कर. ट्रायल कोर्ट का एग्जिबिट 4 पे क्या फाइंडिंग्स है, अपीलेट कोर्ट का एग्जिबिट 4 पर क्या फाइंडिंग्स है. ट्रायल कोर्ट का ही देखा है.
कौन सा इशू है? इशू बताइए.
इसके पहले एक चीज बोला था कि लॉर्डशिप बोला गया था कि whether the first appellate court frame any point for determination or not. First appellate court has ascertained the point for determination that is described
Where is it? पैरा नंबर बताइए.
एक. ये दैट इज पेज पारा लॉर्डशिप 13 का ही लास्ट सेकंड 13 का ही सेकंड पेज. ये 10-12 लाइन के बाद है. हाउएवर देयर इज नो काउंटर क्लेम एंड देयर आफ्टर उसके बाद है. However, there is no counter claim and thereafter the only point required to be considered in this case is regarding the right of the plaintiff appellant.
So this is the point of determination.
Yes. And the court has discussed this controversial point in this case and reversed the trial court judgment. तो ये कहना कि first appellate court has not framed the point for determination, this question is not survived. अब एग्जिबिट 4 पे देखा था. Paragraph 22. trial court judgment.
Para number
20.
22. Yes.
64 of the Evidence Act imposed responsibility upon the parties to prove his case by primary evidence as defined as 62 of the Indian Evidence Act. In the start case, the documents been relied upon by the plaintiff Exhibit 2 and Exhibit 4, and the document been issued in their favor, and hence they are accountable for its original, but the non-production of original will draw the interference against the plaintiffs themselves. The plaintiff have produced the certified copies of these two documents, even if the original thereof has been challenged by the defendant. Section 64 of the Evidence Act provides that document must be proved by primary evidence except in case mentioned in Section 65 of the Evidence Act. In the absence of primary evidence, document can be proved by secondary evidence as considered under the Section 63 of the. Secondary evidence means सेकेंडरी एविडेंस को डिस्क्राइब किया हुआ कि किस चीज को सेकेंडरी एविडेंस माना जाएगा. इन दिस केस सर्टिफाइड कॉपीज गिवन अंडर द प्रोविजन हियर इज द कंटेंट, and this exhibit 4 is the certified copy and come under the definition of secondary evidence. इसके बाद उसका नेक्स्ट उसी को डिस्कस किया गया है, वो सारा सेकेंडरी एविडेंस का जो इलस्ट्रेशन वगैरह के बाद cases in which the secondary evidences relating to the document may be given, secondary evidence may be given of the existence, condition or content of a document in the following cases. फिर उसको डिस्कस किया गया 65 ऑफ एविडेंस एक्ट को सारा डिस्कस किया हुआ है. इसके बाद कोर्ट का उस पर क्या फाइंडिंग्स है. वेयर इलस्ट्रेशन 2B to section 104 of the Indian Evidence Act provide a wishes to prove the secondary evidence that the content of lost of document, you must prove that the document has been lost. Secondary original lost किया गया तभी secondary evidence को consider किया जाएगा. Herein, the plaintiff has already pleaded that his original document is lost during the purview in the proceeding of 145 CRPC law. There is the pleading of the specific pleading of the plaintiff law. और उसी पे एग्जिबिट 4 को ट्रायल को पूरा डिस्कस कर दिया कि चूंकि ओरिजिनल प्रोड्यूस नहीं किए.
आगे पढ़िए इसको फाइंडिंग.
यस,
दैट इज टू से दैट पढ़िए.
Plaintiff have to prove that the document relied upon by him has been lost or he could not produce the same because any of the reason as provided under section 65 of the Indian Evidence Act. In the instant case, the plaintiff in the pleading have contended that the original of Exhibit 4 was filed by him in the proceeding under 145 of the CRPC before STM Nagarutari, wherefrom it went missing. Besides this pleading, no explanation has been given by the plaintiff for non-production of the original of Exhibit 4. And the reason so assigned is not sufficient within itself allowed by the plaintiff to build secondary evidence. Rather, the plaintiff first have to prove the loss of the said document, but the plaintiff have failed to adduce any evidence in this regard. Further, it is also apparent from Exhibit 4 that the same copy was filed before STM Nagarutari court as the original endorsement by the court of the SDM Nagarutari has been inscribed thereon. Also order dated itna passed by the learned SDM Garhwa in case number itna, the certified copy of which has been produced by the defendant and where the mark the same as Exhibit A.
It was marked Exhibit A on 29/11/99.
Yes. In the court below, in the proceeding under section 145 CRPC. और वहीं से ये सर्टिफाइड कॉपी लिया गया है। और ट्रायल कोर्ट का फाइंडिंग था
आपका
कि
डेट ऑफ लॉस क्या है? डेट ऑफ लॉस ऑन विच डे डिड यू यूज इट?
नहीं, हम तो सबमिट कर दिया ना,
कब
वहां से फिर हमको नहीं मिला। डेट ऑफ लॉस तो एसडीएम कोर्ट में बताया जाएगा कि कब लॉस्ट हुआ। आई हैव सबमिटेड दिस डॉक्यूमेंट इन द एसडीओ को। एसडीओ कोर्ट गिवन द इंडोर्समेंट मार्क्ड एग्जिबिट ए। The existence of the document is cannot be denied, Lord,
No,
because there is a finding of the SDM court.
अगर किसी को किसी का सिग्नेचर वेरिफिकेशन के लिए भेजना है तो कैसे भेजेंगे?
हो सकता, लेकिन
भेज सकता
अगर
ना।
इसके लिए प्लेंटिफ रिस्पॉन्सिबल है, प्लेंटिफ तो कोर्ट में डॉक्यूमेंट सबमिट करते
अगर
हैं।
कोर्ट में डॉक्यूमेंट सबमिट किए हैं
हाँ।
तो हाउ डिड यू कम टू नो दैट इट हैज बीन लॉस्ट?
हमको नहीं मिला।
नहीं मिला मतलब? डिड यू अप्लाई फॉर इट? डिड यू आस्क फॉर द ओरिजिनल फ्रॉम द कोर्ट?
ये बिल्कुल
हैव यू
certified-
प्रूव्ड इट? हैव यू प्रूव्ड इट दैट कि भाई हम तो कोर्ट में ओरिजिनल फाइल किए, हम उसका अप्लाई किए कि हमको ओरिजिनल वापस कर दे, कोर्ट डिक्लाइन कर दिया कि इट हैज बीन लॉस्ट। उसके बाद कोर्ट भी एफआईआर करता है कि नहीं करता है? ओरिजिनल सेल डीड किसी का लॉस्ट का मतलब समझते हैं आप? हाउ सीरियस इट कैन बी?
वो नहीं हुआ,
वो तो कुछ नहीं
थोड़ी
हुआ।
देर के लिए मान लिया कि नहीं हुआ,
हाँ,
समझ गए। लेकिन ये अगर इलिटरेट कोई प्लेंटिफ है and that document is once considered by the SDM also. There are two aspects also. One
you
document
see, execution of document is not in dispute because it is a registered document.
meaning thereby there is one document.
No, there is one document because you have taken certified copy exhibit A from where?
From SDM court.
From SDM court.
Yes.
Okay, you have not brought it from the registry office.
इसको वेरीफाई कर, इस पॉइंट पे हम वेरीफाई
दोनों में अलग बात है ना,
दोनों
एक बात
हम
नहीं
समझ
है।
रहे हैं। उसमें शायद रजिस्ट्री ऑफिस से है क्या, ओरिजिनल डॉक्यूमेंट को हम कंपेयर करते हैं उसके बाद ही। लेकिन देयर इज अ फाइंडिंग इन द प्रोसीडिंग।
यही तो बात है इनका ये कहना है कि जो फाइंडिंग ट्रायल कोर्ट ने दिया है वो सारा फाइंडिंग एपेलेट कोर्ट ने मीट किया। अब उसको एग्जिबिट 4 को कैसे डिस्कस किया
रजिस्ट्री
उसको
ऑफिस से निकला उनके इन्हीं का प्लीडिंग अपने
ठीक है, मान गया उसको, हम मान गया उसको, हम डिस्प्यूट नहीं कर रहे। जो चीज हम नहीं जान रहे उसके बारे में बोलना ही बेकार है। हमारे कहने का मतलब कि एग्जिबिट 4 के बारे में जो ट्रायल को डिस्कस किया उसको अपीलेट कोर्ट ने डिस्कस किया कि नहीं किया। अब अपीलेट कोर्ट को देखा जाएगा एग्जिबिट 4 को किया गया, सिर्फ ये बोला कि नॉन प्रोडक्शन ऑफ ओरिजिनल डॉक्यूमेंट दैट इज एडवर्स इंटरफेरेंस प्लेंटिफ का होगा, उसी के आधार पे हमारे टाइटल सूट को डिसमिस कर दिया। अब उसको अपीलेट को डिस्कस किया, एग्जिबिट 4 को देखा, दैट इज इन पारा 13 ऑफ द।
I want to see exhibit 4 का discussion also. I also want to see the discussion of the findings of the learned trial court कि वो बोले कि learned trial court ने गलत finding record किया है
यस,
और appreciation of section 65 and 64 of the evidence
वो
that
सारा।
has been wrongly done.
यस, अपीलेट कोर्ट में देखा पारा 13, अपीलेट कोर्ट के जजमेंट पारा 13।
Correct. ये तो appellate court का judgment पैरा नंबर
13
पढ़ी।
The Exhibit 4 is the document of the year 1969. Ram Prasad Ram was not alive, the document executed during trial and not available to prove the controvert his signature. The documents being 30 years old would have been marked so. If the original would have been produced, the plaintiff appellant has cited to the CR 16SC, wherein the Honorable Apex Court has held that the certified copy of the registered sale deed is admissible in evidence, even if it is not proved by calling witness. Section 79 of the Evidence Act states that certified copies shall be presumed to be genuine, which is admissible as evidence. The plaintiff appellant were under duty to produce best evidence, but it was not mandatory on their part to produce the original. The Exhibit 4 has been certified from the office of the registrar to be true copy. The plea of the defendants respondent that the deed of partition was manufactured has to be examined. The plaintiff appellants has filed Exhibit 1, Exhibit 1 by 1, Exhibit 1 by 2. ये इसको भी हम लोग जो सब्सटेंशियल क्वेश्चन नंबर सी में हमको इसको किया हुआ एग्जिबिट 1 सीरीज को आर रेंट रिसीव्ड 456 डिसमिल ऑफ द लैंड रनिंग इन द नेम ऑफ फागु दुसाद फागु राम and has been proved by PW4 Krishna Tiwari, PW5 Devanarayan Shukla and PW7 Kokileswar Prasad. On the other hand, the defendants respondents have pleaded in para 11 of the written report that the rent receipt is being issued in the name of defendant number 2 and 1, but no rent receipt or any other deed or relevant document has been filed by on their behalf. The only two documents filed on behalf of the defendants respondents are the order dated 29/11/1919 passed by the executive magistrate Nagar Utari and order sheet of revisional court. Copy of the judgment passed by the revisional court has also not filed. Section 45 CRPC is intended to consider land, water and boundary disputed which may lead to apprehension of breach of peace, and in such proceeding an executive magistrate if possible can declare possession of a party as on the date of the dispute or may consider dispossession within 2 months prior to the said dispute. Under this provision, the declaration of possession is temporary in nature and is not based on any right or title of the party. The documents filed by the defendant respondent has very weak in evidentiary value. Exhibit 1, 1 by 1, Exhibit 1 by 2 corroborates the claim of the plaintiff appellant with regard to 56 dismissal of the land obtained by Phagu Ram alias Phagu Dosal in amicable partition dated 7/6/1969. The learned lower court has taken hyper-technical view to discard Exhibit 4 and the consideration regarding the partition being not equitable is also unwarranted. In cases of natural love and affection, it is immaterial that a person gives a bigger chunk or valuable portion of to his near and dear. The defendant respondent has pleaded that the defendant number 1 has received 19 dismissal of land through Sada Patta. No such document has been filed on behalf of the defendant and the property also cannot be transferred through Sada Patta. However, there is no counter claimant therefore. The only point required to be considered in this case is regarding the right of the plaintiff appellant. The learned lower court has also wrongly considered Section 46 of the CNT Act as the case of the plaintiff's appellant is that Ram Prasad Ram was the elder brother and Karta of the family and therefore his name was recorded in the settlement. It is the case of the plaintiff appellant that Exhibit 4 reflects family settlement and it is only partition, not transferring the land by the sale or gift. In view of the above facts, and sir, I am of the considered view that Exhibit 4 has evidentiary value which is well proved and corroborated 56 dismissal land has validly come in right title and possession.
This is with regard to
This is with regard to Exhibit 4 Lordship, is number
the question of law number
3, 2 and 3,
A and B.
B and C. और A को भी वही किया जाए अगर उसको करेक्ट कर लिया जाएगा एग्जीक्यूटिव A को.
वो तो हम लोग करेक्ट कर लेंगे.
These findings is regarding B and C.
You read question of law number B once again.
B. whether the learned court of appellant below has applied correct principle of law and was justified in relying upon the Exhibit 4, a true copy of a partition deed, and also has further misconstrued with the
Exhibit 4 was a true copy or a certified copy?
ये तो सर्टिफाइड कॉपी, ये जो डिस्कशन किया गया हर जगह सर्टिफाइड कॉपी लिखा गया
नहीं, ट्रू कॉपी लिखा है। एपिलेट कोर्ट उसको ट्रू कॉपी लिखा है।
एक मिनट देख लीजिए। Certified copy of deed of
The
partition.
exhibit 4 has been certified from the office of registry to be true copy.
वही होता है, सर्टिफाइड कॉपी में सर्टिफिकेट होता है। सर्टिफाइड कॉपी का मीनिंग ही होता है कि सर्टिफाइड
वो
दैट
true
द
करके देगा, certified to be true.
यस, वो एक सर्टिफिकेट बनाएगा। ट्रू कॉपी जो होता है उसमें सर्टिफिकेट नहीं होता है, और सर्टिफाइड कॉपी में एक सर्टिफिकेट बाय कॉम्पिटेंट ऑफिसर।
That's right. So it is not a true copy, it is a certified copy.
It is certified that this document is certified to be true for of the
आगे
original.
पढ़िए. And has further misconstrued the admissibility of the said document as taking
Said
secondary
document as
evidence.
taking secondary evidence when in absence of attesting the fundamental facts of 65. Fundamental 65 था कि original is lost. That is in the pleading that the original is lost in the during the course of litigation of 145 CRPC or 145 CRPC, but that is mentioned. Non-consideration of 65 in correct manner by the trial court. Hence, the first appellate court is given the finding on exhibit.
Referring to 30-year-old document.
Yeah. There are two. One thing is 30-year document. As per the evidence act, that is admissible in evidence. And there are two है कि अगर original को अगर 65 evidence act के अंदर prove किए कि original is not in hand of me, अगर वो प्रूव करते हैं, सेटिस्फाइड करते हैं कोर्ट को इन टू मैनर, तो उनको सेकेंडरी एविडेंस में
तो
Certified
appellate court का कोई ऐसा फाइंडिंग है कि that it was not in your possession?
अपीलेट कोर्ट को लोअर कोर्ट में प्लीडिंग था, प्लेंटिफ का प्लीडिंग ही था।
नहीं, appellate court में कोई
यस,
ऐसा
उसी को
finding-
देखा, हाँ, उसको उसी पारा 30 में देखा जरूर।
appellate court में कोई ऐसा फाइंडिंग है that मतलब आपके पास it was not required to be produced at all while reversing the finding of the learned trial court.
हाँ, वो पारा 30 में पूरा डिस्कस किया हुआ है। हम लोग जहाँ पढ़ के छोड़े वहाँ से।
It only says that the learned trial court has been hyper-technical, has taken a hyper-technical view.
इसमें
इसके
हाइपर
अलावा
टेक्निकल है क्या? अगर वो हाइपर
appellate court तो वही लिखा है ना कि hyper-technical view. फाइंडिंग तो appellate court का इतना ही है कि ये hyper-technical.
जो एग्जिबिट नॉन कंसीडरेशन ऑफ एग्जिबिट 4 मेन उसको सेटिस्फाइड किया गया, उसमें एक मेन उसका पॉइंट था कि दैट इज नॉन कंसीडरेशन ऑफ एग्जिबिट 4 इज नॉट मेंटेनेबल इन IOF. Once there is one side, there is one document that is certified document, proof document that is not considered by the trial court.
तो बाकी सब क्या है? Whether the appellate court misdirected himself relying upon exhibit 1, 1/1, 1/2.
ये rent receipt है,
So rent
that
receipt is basically for possession.
that is for possession. What is the dispute here, Lordship? ये सब समझना इसके पहले prior to entering into the case, Lordship, कि तो plaintiff is descendant of the ancestor who possessed the land in question, Lordship. There was a proceeding under section 145 CRPC, Lordship. दोनों पार्टी में लड़ाई हुआ, डिफेंडेंट आए और एक 145 CRPC का एक लिटिगेशन इनिशिएट किया गया। उस लिटिगेशन में किया गया कि डिफेंडेंट के पोजीशन को डिक्लेयर कर दिया गया। देयर आफ्टर रिवीजन हुआ लॉर्डशिप, रिवीजन में भी उनको कंफर्म कर दिया गया लॉर्डशिप, रिवीजन डिसमिस हो गया। thereafter the plaintiff filed this title suit for declaration of his right, title and possession. उसमें तो 145 सीआरपीसी का भी जो ये ऑर्डर था, ट्रायल कोर्ट 145 का जजमेंट, वो एग्जिबिट ए जो डिफेंडेंट के द्वारा लाया गया एग्जिबिट ए, एंड रिविजनल कोर्ट का जजमेंट को लाया ही नहीं, दैट इज नॉट ब्रॉट बाय द, सिर्फ डिसमिस किया गया, ऑर्डर शीट लाया गया कि दैट रिवीजन इज डिसमिस्ड, एक्सेप्ट दिस डॉक्यूमेंट, डिसीजन ऑफ 145 सीआरपीसी, defendant has not brought any document.
And oral evidence?
There is oral evidence. अब हो गया कि if there is documentary evidence, जो dispute of property है, तो documentary evidence prevail over the oral evidence.
बात ये है कि जो appellate court है, उन्होंने कोई oral evidence consider किया?
चूंकि फर्स्ट अपीलेट कोर्ट में अपीलांट जो है जो क्वेश्चन को रेज किया, उसी क्वेश्चन का डिसाइड करेगा अपीलेट कोर्ट। जैसे यहाँ पे सब्सटेंशियल क्वेश्चन जो फ्रेम किया गया है,
तो 145 में अगर सब कंक्लूसिव ही है, 145 इज अ कंक्लूसिव पीस ऑफ एविडेंस, डू यू वांट टू से दैट?
यस, नहीं वो उसको डिस्कस किया, 145 सीआरपीसी के ऑर्डर को भी डिस्कस किया, दैट इज ओनली विथ रिस्पेक्ट ऑफ द पोजेशन ऑन द डेट ऑफ इनिशिएशन ऑफ द प्रोसीडिंग। 145 सीआरपीसी का जो ऑर्डर होता है और प्रोसीडिंग होता है, माना जाता है कि ऑन द डेट ऑफ इनिशिएशन ऑफ प्रोसीडिंग किसका पोजीशन था, ऑन द डेट ऑफ डिस्प्यूट, ऑन द डेट ऑफ इनिशिएशन ऑफ प्रोसीडिंग डिफेंडेंट का पोजीशन था, उस पोजीशन को गलत डिक्लेयर किया, उसी के अगेंस्ट में हमने रिवीजन लाया जो डिसमिस हुआ, तो मैंने टाइटल सूट लाया और उस पोजीशन को बोला गया वन साइड आई हैव द डॉक्यूमेंट्री एविडेंस टू प्रूव द माय पोजीशन, that is exhibit 1 series rent receipt in my name. Defendant has pleaded that they have a rent receipt but has not produced rent receipt in the court below. That finding also given at the first appellate court judgment. अगर पोजीशन को डिक्लेयर किया जाए तो किसी डॉक्यूमेंट के आधार पर किया जाए, I have also document in my name during the proceeding of 145 CRPC. That my document is जो यहाँ exhibit 1 series को वहाँ कंसीडर नहीं किया है, तो मैंने टाइटल सूट लाया और डिफेंडेंट अपने
साइड पे एविडेंस Is there any law to say that if a document is 30 years old,
yes.
then the original need not be produced?
ये एक जजमेंट ही है लोग, सिर्फ इसमें जो साइड किए हैं 1213 को डिफाइन किए हैं, 2008 वॉल्यूम 3 झारखंड सिविल report 16 Supreme Court, wherein the Honorable Apex Court had
2008, just a moment. Volume?
Volume 3, Jharkhand, CR 16 SC.
पार्टी का नाम बताओ।
पार्टी का नाम तो नहीं है, जब इसी से हम लोग देखें।
झारखंड CR क्या हुआ? CR सिविल लॉ
डाउनलोड कर लेंगे लोग, सिर्फ डाउनलोड करके हमें भेजो।
हाँ बताइए क्या है, क्या बताते हैं?
डाउनलोड करके।
क्या बोलते हैं
ये बोलता उसी में डिस्क्राइब किया हुआ है कि where in the honorable apex court has held that the certified copy of the registered sale deed is admissible in evidence even if it is not proved by the calling witness. फिर बोलता सेक्शन 79 of the evidence act states that the certified copy shall be presumed to be genuine which is admissible as evidence. Section 79 को देखा 79 को देखा presumption as to genuineness of the certified copy. The court shall presume to be the genuine every document purporting to be a certified certificate, certified copy or other document which is by law declared to be admissible as evidence of any particular fact and which purports to be the duly certified by any officer. Section 79.
You see, it is one thing to say that the document was executed.
Yes.
It is another thing to say that document was executed by a particular person. What was their case? Did they say that the document is forged, fabricated? क्या ऐसा plea उनका था कि क्या plea था? Defendant का क्या plea था? With regard to Exhibit 4.
Defendant denied that document lordship, but
Denied the execution of that document by the
right. Pleading on the
और दोनों दो डॉक्यूमेंट पे फाइंडिंग है एग्जिबिट 4 पर भी है और एग्जिबिट 2 पर भी है एग्जिबिट 2 क्या है
exhibit 2. Exhibit is the one gift deed.
दैट वाज आल्सो नॉट प्रोड्यूस्ड इन ओरिजिनल
That is produced. उसका देखते हैं.
नहीं वो भी नहीं प्रोड्यूस
नहीं
हुआ
हुआ।
है एग्जिबिट 2 के बारे में क्या फाइंडिंग है एप्लेट कोर्ट का
उसको कंफर्म नहीं किया है।
उसको confirm.
उसके बारे में कोई डिस्कशन हमको दिखा नहीं है एग्जिबिट
नहीं चूंकि वो चैलेंज नहीं किया था फर्स्ट अपीलेट कोर्ट में ताकि 2 का जो फाइंडिंग लोअर कोर्ट का था उस पर डिस्प्यूट नहीं था ट्रायल कोर्ट का एग्जिबिट 2 पे जो फाइंडिंग्स था
दैट वाज नॉट अंडर डिस्प्यूट और ये जो एग्जिबिट 4 किसने एग्जीक्यूट किया था नाम क्या था उसका एग्जीक्यूट करने वाले का एग्जिबिट 4
एग्जिबिट 2 को सर्टिफाइड कॉपी
Exhibit
को
4
प्रूव नहीं किया
एग्जिबिट 4 किसने एग्जीक्यूट किया था Who
Plan-
was the executor?
एग्जीक्यूट किया था एंसेस्टर ऑफ द प्लेंटिफ
नाम
राम प्रसाद
नाम ये कुंवर काली देवी कौन है?
ये डिफेंडेंट बोले कि कुंवर कलिया देवी इज द डाउटर ऑफ द कॉमन एंसेस्टर एंड शी हैज राइट इन द डिस्प्यूटेड but he has not produced any document in support of his assertion made in the defendant.
No, but a portion of the property was transferred in her name earlier
Yes, but
by
he,
virtue of a gift deed.
कुंवर कलिया को नहीं दिया
एक
He
portion
has-
दिया गया था
नहीं कुंवर कलिया को नहीं कुंवर कलिया इन लोगों को दी।
और कुंवर कलिया है
हाँ
अच्छा
कुंवर कलिया इन लोगों को दिया
और
है।
लेकिन जो
उस
कुंवर-
पर कुंवर कोर्ट का फाइंडिंग नहीं है कि उनका नहीं किसी तरह का क्योंकि कुंवर कलिया बेटी ही नहीं थी। जीरवा बेटी थी उसका राम प्रसाद की, जो यहाँ प्लेंट है और ये लोग राम प्रसाद के वर्षान नहीं है राम प्रसाद के भाई के वर्षान और प्रॉपर्टी राम प्रसाद की थी जिस
entire claim of the defendant based upon the order passed in the 145 CRPC and
इफ योर लेडीशिप विल अलाउ मी तो हम इस पर देंगे चंदन मंडल का केस अपने कोर्ट का कि जो कहा गया कि विदाउट कॉलिंग कि वो पब्लिक डॉक्यूमेंट है उस पर भी कोर्ट ने अपने फाइंडिंग दिया कि नहीं है इसको देखा जाएगा
जो डॉक्यूमेंट प्रूव हुआ विथ ऑब्जेक्शन नहीं किया डिपेंडेंट वहां ऑब्जेक्शन ही नहीं किया लॉर्डशिप
दिखा दे रहे हैं। इसको देखा जाएगा। कोई पॉइंट फॉर सोल्यूशन ही नहीं बना है किसी तरह
वही दिखा रहे हैं जो पॉइंट पर्टिकुलर
इसमें स्पष्टली आया है जजमेंट अपने ऑनरेबल कोर्ट का पूरा पॉइंट फॉर डिटेल पूरा पॉइंट डिटेल पैरा 17 में दिया गया है कि सेकेंडरी एविडेंस जब ओरिजिनल रहेगा पब्लिक डॉक्यूमेंट तब उसका कर सकते हैं, तो ओरिजिनल ही प्राइवेट डॉक्यूमेंट है, ओरिजिनल स्टेटेड इज प्राइवेट डॉक्यूमेंट, तो 65 में नहीं आएगा।
नहीं समझे क्या बोले आप?
काइंडली हैव टू 65 काइंडली हैव टू 65E।
Okay. And then?
When the original is a public document, तब उसका सर्टिफाइड कॉपी सेकेंडरी एविडेंस में लिया जाएगा। तो यहाँ तो लॉस्ट की बात है और लॉस्ट प्रूफ नहीं है, तो सेकेंडरी एविडेंस लीड कैसे हो? ओरिजिनल सेल लीड जो है अपने आप में प्राइवेट डॉक्यूमेंट है और उसको गवाह से प्रूफ कराना होगा, और इसीलिए जब स्पेसिफिक केस है कि नहीं इम्पर्सोनेशन का केस है, ताकि वेरीफाई ना हो, चेक ना हो, प्रोड्यूस नहीं किया। अब फाउंडेशनल फैक्ट कहते हैं वही डॉक्यूमेंट जो एसडीओ के यहाँ
उसी को 79 के साथ पढ़ लिया
कोर्ट ने आजा जहाँ तक
हमको जो सर्टिफाइड कॉपी मिला है, दैट सर्टिफाइड कॉपी इशूड ऑन द बेसिस ऑफ द रजिस्टर्ड मेंटेनिंग द रजिस्ट्री ऑफिस।
और जिस एग्जिबिट की जिस सब्सटेंशियल क्वेश्चन ऑफ सी पर कहते हैं एग्जिबिट 1/2 जो रेंट रिसीट है, रेंट रिसीट पर भी ट्रायल कोर्ट का क्या फाइंडिंग है कि कोई पार्टिकुलर ही मेंशन नहीं है। अपलेट कोर्ट कहते हैं कंफर्म कर रहा है, ट्रायल कोर्ट का देख लिया जाए, जो देख लिया है ट्रायल कोर्ट का फाइंडिंग पर हम दिखा रहे हैं। ट्रायल कोर्ट ने स्पष्ट कहा है कि कोई पार्टिकुलर मेंशन नहीं है। जिस एग्जिबिट रेंट रिसीट, हालांकि 2 नॉट डॉक्यूमेंट ऑफ टाइटल, लेकिन पैरा 25 में ट्रायल कोर्ट ने उस रेंट रिसीट को ही कह दिया है कि exhibit 1/2 but the perusal they have displayed that these rent receipt do not contain the plot number। ट्रायल कोर्ट का फाइंडिंग है, तो अपलेट कोर्ट कहाँ उसको विचार किए किसी तरह का? तो इधर न कोई पॉइंट फॉर डिस्कशन बना है, न किसी तरह का कोई डिस्कशन है, न किसी तरह का। ट्रायल कोर्ट ने उस जिस एग्जिबिट की बात बोल रहे हैं उस एग्जिबिट के बारे में तो ट्रायल कोर्ट का फाइंडिंग है ही है रेंट रिसीट के बारे में कि उसमें कोई पर्टिकुलर प्लॉट का नहीं है। एग्जिबिट 4 जो है सो डॉक्यूमेंट एडमिसिबल नहीं है, दैट कैन बी रेज्ड।
और ये बियॉन्ड प्लीडिंग्स की क्या बात है?
बियॉन्ड प्लीडिंग्स पे ट्रायल कोर्ट ने डील किया है तो विटनेसेस का, क्योंकि जब प्लेंटिफ का खुद का एविडेंस का ही डिस्कशन अपलेट कोर्ट ने किया, जो खुद प्लेंटिफ है उसका ही डिस्कशन नहीं किया है, क्योंकि प्लेंटिफ ने उसका क्या है सब उसको भी दिखा देते हैं। ट्रायल कोर्ट ने उसको भी डील किया है। ट्रायल कोर्ट ने पैरा 24 में कहा है कि दो द प्लेंटिफ हैव मेजरली फेल्ड टू स्टेट द ग्राउंड्स एज टू व्हाई ही लेड सेकेंडरी एविडेंस टू प्रूव हिज केस। Plaintiff by means of oral evidence through PW1, PW2 have also tried to lead evidence beyond the pleadings. Beyond the pleadings, trial court has dealt it. Beyond the pleadings, as well as the documents produced by me. In as much, both the two witnesses during the chief has stated that Ram Prasad Ram and Phagu Ram both obtained the settlement jointly, जो कि केस इनका नहीं। इनका केस है कि चाचा का था, हमारा बाद में बंटवारा हो गया कि राम प्रसाद राम, ईमान है कि राम प्रसाद राम का एक्सक्लूसिव प्रॉपर्टी था, लेकिन राम प्रसाद ने वसीका कर दिया, इन्होंने प्लीडिंग में दिया 79, लेकिन 79 का नहीं है, वो भी प्लीडिंग बियॉन्ड एविडेंस हो जाएगा 69 का है।
79 का है।
हाँ, ये 79 प्लीडिंग का है, लेकिन 69 का है जो एग्जिबिट 4 है वो 69 का है।
तो इनका इस आर्गुमेंट के बारे में आपको क्या बोलना है?
किसका?
जब डॉक्यूमेंट 30 इयर्स ओल्ड है,
30 इयर्स ओल्ड डॉक्यूमेंट कहाँ कुछ प्रिजम्पशन ओरिजिनल का ना होता है कि सर्टिफाइड कॉपी का प्रिजम्पशन होता है। ओरिजिनल डॉक्यूमेंट अगर प्रोड्यूस होगा कस्टडी में तो उसका प्रिजम्पशन है, ओरिजिनल का, सर्टिफाइड कॉपी का कुछ नहीं होता है। ओरिजिनल अगर लाया जाएगा वो कस्टडी प्रूफ करेगा, वो भी कस्टडी प्रूफ करेंगे कि हम अपने कस्टडी से दाखिल कर रहे हैं, उसको बाई मोड दिखाना होगा अपने कस्टडी से दाखिल कर रहे हैं, तब उस पर इस सर्टिफाइड कॉपी का थोड़ा प्रिजम्पशन होता है किसी तरह का। सेक्शन 90 में, सेक्शन 90 ऑफ एविडेंस एक्ट
नहीं, उन्होंने बोला है कि अगर मान लीजिए ओरिजिनल प्रोड्यूस कर भी देते तो भी वो 30 years old document.
So that cannot be observed. Where there is dispute, where the parties are denying execution, deny कर रहे हैं, तो contents कैसे प्रूफ होगा? सिर्फ सर्टिफाइड कॉपी दाखिल कर देने से contents कैसे प्रूफ होगा? अच्छा, और ये पब्लिक डॉक्यूमेंट नहीं है। डेक्कन मिल्स में अभी रिसेंटली डेक्कन पेपर मिल्स के केस में पैरा 22 में कहा गया है, इसको भी मुझे दे देना है। कि सेल डीड जो है
इसमें सर्टिफाइड कॉपी के लिए नहीं है प्रिजम्पशन 30 years old।
कहीं नहीं दिखा दे
को दिखा दे, सेक्शन 79 को दिखा दे।
तो दूसरी चीज
सेक्शन 65 में merely because a document is 30 years old, are you absolved from producing it before the court? Is there any finding by the learned appellate court that the explanation for not producing the document is correct? Is there any finding of the learned appellate court? Because the trial court has said that the explanation for not furnishing the document is not accepted. Trial court has not accepted that explanation,
Yes.
isn't it? Is there any finding of the learned appellate court that this finding of the learned trial court that the document has not been produced is not correct? ऐसा कोई finding है?
Yes, yes. वही 12-13 जो हम बोल रहे थे
हाँ,
वो-
उसमें खाली इतना ही है कि हाइपर टेक्निकल।
हाँ, उतना ही
लॉ तो टेक्निकल है ही।
नहीं एक चीज हम दिखलाते हैं।
लॉ तो हाइपर टेक्निकल क्या, हाइपर टेक्निकल से भी ज्यादा हाइपर टेक्निकल।
ये तो यहाँ तक कहती वही डॉक्यूमेंट फाइल हुआ था एसडीओ के यहाँ भी।
आपके क्रिमिनल केस में एक तो 313 में जवाब क्वेश्चन नहीं पूछने से एक्यूटल हो जाता है, होता है ना। लॉ बहुत टेक्निकल है। ये कहना कि लॉ टेक्निकल है ये तो नहीं, कोई एक्सप्लेनेशन नहीं है ना।
उसको डिस्कस किया है।
बताइए। आप देख लीजिए।
The plaintiff appellant were under duty to produce best evidence, but it was not mandatory on their part to produce the original. The exhibit 4 has been certified from the office of the registrar.
कहाँ से ये लिख रहे हैं? It was not mandatory for them to produce the original.
Yes.
Where is the finding
ये
that the
judgment
explanation?
एक judgment को sign
Where is the finding that his explanation for not producing the original is accepted? Does the court say that rejection of the document and the rejection of explanation, as has been done by the learned trial court, is incorrect? अब दो पैरेलल फाइंडिंग आ गया है, एक ट्रायल कोर्ट का फाइंडिंग आ गया है और एक एपीलेट कोर्ट का फाइंडिंग।
अपीलेट कोर्ट तो बोला कि अगर उसको मान भी लिया जाए, the admissibility of evidence में डिस्कस कर दिया है।
You see, the trial court has rejected the exhibit 4 and exhibit 2 on account of non-acceptable explanation for not producing the same. Right? The explanation has not been accepted by the learned trial court.
But that is accepted by the appellate.
No, where is it that the appellate court says that yes, this explanation of non-production is acceptable to the appellate court, and the trial court has committed error in appreciating the provisions of section 65 of the Evidence Act. कहाँ है? इसीलिए क्वेश्चन देखिए, दो अगर कोर्ट अपना अपना फाइंडिंग दे देंगे तो हमारे पास सेकेंड एपीलेट जुरिस्डिक्शन में हम लोग दोनों में से एक फाइंडिंग चूज नहीं कर सकते हैं ना। अगर फर्स्ट एपीलेट कोर्ट ट्रायल कोर्ट के रीजन को मीट करते हुए एक जजमेंट देंगे तो हम लोग ये देख सकते हैं भाई वो मीटिंग ठीक है कि नहीं है, रिवर्सल ठीक है कि नहीं है, विच ऑफ द व्यू शुड बी प्रिवेल्ड। लेकिन इसमें एपीलेट कोर्ट में वो सब डिस्कशन नहीं है। आखिर ये जो ऑर्डर 41 रूल 31 जो है किसी काम से बना है ना, सुप्रीम कोर्ट के जजमेंट से किसको कैसे डील करना। और रिवर्सल के केस में इट इज एब्सोल्युटली मैंडेटरी। वो आपको जजमेंट दिए, देखिए आप उसमें सारे सुप्रीम कोर्ट के जजमेंट्स होते हैं।
लेकिन रिवर्सल के केस में ये भी है कि इफ ऑल द एविडेंसेस,
देखिए आप अगर इस तरह से बोलेंगे तो आपको जजमेंट दिखाना पड़ेगा कि कोई जरूरत नहीं है उसको मीट करने का। अगर इफ ऑल द
हम वो
एविडेंसेस
चीज
आर
नहीं बोल रहे,
रीअप्रिशिएटेड,
हम वो चीज नहीं बोल रहे हैं। अगर सारे एविडेंसेस अवेलेबल है बिफोर कोर्ट प्लॉट फॉर कंसीडरेशन, तो देयर इज नो नीड ऑफ रिवर्सल।
नो नीड ऑफ रिवर्सल। रिवर्सल तो किया ही है।
नहीं, यहाँ सेकेंड अपील में हम बोल रहे हैं सारा एग्जिबिट 4 क्या है वो भी डिस्कस किया हुआ है, उसको कंसीडर किया एडमिसिबल इन एविडेंस है कि नहीं है, सिर्फ एक फाइंडिंग से आया।
आप बात नहीं समझ। ट्रायल कोर्ट ने रीजन ए देकर सूट को डिसमिस कर दिया, एपीलेट कोर्ट ने रीजन बी देकर सूट को अलाउ कर दिया। अब रीजन ए को बिना मीट किए हुए एपीलेट कोर्ट सूट अलाउ नहीं कर सकता, ऐसा हमारी समझ है। सब्जेक्ट टू इफ यू से एनी कॉल लेके आइए, जजमेंट लेके आइए। हम अपने जजमेंट को रिव्यू कर लेंगे, कोई दिक्कत नहीं है। लेके आइए कि एपेलेट कोर्ट को कोई रीज़न अलग से देने का ज़रूरत नहीं है, पूरा एविडेंस कंसिडर कर लिया तो काफ़ी है। ये चीज़ क्रिमिनल अपील में दूसरा तरह से चलता है, लेकिन इसमें तो देयर इज अ स्पेसिफिक प्रोविजन। क्रिमिनल अपील में भी ट्रायल कोर्ट का जजमेंट को कंसिडरेशन एकदम नेसेसरी है, डिस्कशन एकदम नेसेसरी है। ऐसा नहीं है कि एपेलेट कोर्ट एक खुद भी फाइंडिंग देते और आप ट्रायल कोर्ट के फाइंडिंग्स को कंसिडर ना करें। तो दो अलग अलग कोर्ट का डिफरेंट रीजन से फाइंडिंग है, तो कैसे ही हम लोग इसको सेकेंड अपील में ये क्वेश्चन ऑफ लॉ को कैसे हम लोग रिकमेंड करें? नहीं हो सकता। देख लीजिए, समझ लीजिए।
फर्स्ट अप्रैल को तो इशू ऑफ लॉ एंड फैक्ट दोनों एड्रेस करना है,
दोनों को एड्रेस करें।
दोनों करना है। अब पूरा कोई इवन प्लेंटिफ का भी इनका
अब नहीं आइए जजमेंट, कोई बात नहीं, हम लोग उसको भी कंसिडर करें। आपको एक जजमेंट दे दिए, वो कहाँ है, उसको वापस करिए, वो मेरा कॉपी है। आप कोई केस नंबर नोट कर लीजिए, वो मेरा प्रॉपर्टी है, आप उसको प्रिंट उसका निकालिए।
28
देखिए, सेकेंड अपील नंबर 390 और 27 heard the learned counsels appearing on behalf of the parties at length. During the course of argument, it appeared that the learned trial court, while rejecting, वो दे दीजिए हमको वापस। During the course of argument, it transpired that the learned trial court, while refusing to accept Exhibit 4, which was certified copy of the original, has cited reasons.
perhaps true copy
from registry office.
हाँ
नहीं सर्टिफाइड कॉपी तो हम ट्रू क्या मानेंगे, लिखा हुआ सर्टिफाइड कॉपी
अब दिखा वही निकाल
अच्छा ठीक, अच्छा सुन।
perhaps true copy
The learned trial court, by refusing to accept Exhibit 4, has discussed the material to hold that
सच्ची पकड़ी
the petition and has rejected the explanation furnished by the
true copy है true copy
has rejected the explanation furnished by the plaintiff for non-production of the original. It further appears that the learned appellate court, while reversing the finding, has not met with the reasons which has been assigned by the learned trial court for not accepting Exhibit 4. However, the learned counsel appearing on behalf of the respondents has submitted that the entire materials were considered by the learned appellate court while reversing the judgment of the learned trial court. The learned appellate court has also taken into consideration the fact that had this document been produced in original, it would have been accepted. It would have been admissible as the document itself was 30 years old and the executor of the said document was not alive. He submits that he has gone through the judgment passed by this court in second appeal number 28 of 2017.
मैंने दिया
कोई बात
हाँ हाँ ठीक
किसी ने
हाँ किसी जजमेंट नाम उसमें
देखिए हम लोग का
नहीं
प्रॉब्लम क्या है अपना judgment
सॉरी
He has gone through the judgment passed by this court in second appeal number 28 of 2017 and has submitted that he shall examine this judgment and come up with his own judgments for consideration. कब कल?
नेक्स्ट
Pose this case for further arguments on next Tuesday in the supplementary list to be taken up as the first case. कोई हेस्ट में हम लोग को जजमेंट नहीं करना, लेकिन चीज़ों को जैसा होना चाहिए वैसा होना है, ठीक है? वी आर नॉट ऐसा कोई माइंड क्लोज करके नहीं बैठे।
नहीं, एक सिविल केसेस में एक होता है प्रिंसिपल ऑफ प्रीपोंडेंस रूल्स, नियर
आप देखिए सुप्रीम कोर्ट के जजमेंट्स पढ़िए, अपने पटना हाई कोर्ट के जजमेंट्स पढ़िए,
पढ़
ठीक है? उसमें सारा कोर्ट करके किए हैं और हमारे हाई कोर्ट के बहुत ही माननीय वकील साहब ने बहस किया है, तो हम एज्यूम करते हैं कि उन्होंने सारी चीज़ें सही से प्लेस की हैं। How to do? Pass over?
After this item 6 second appeal 142 of 2019.
हाँ ये नहीं आए ना मिस्टर बी के रूबी आए थे क्या? कहाँ है? या आपके पास है फाइल?
Lord,
बताइए.
Lord, against the concurrence affirmance lordship. The defendant lordship, the appellant is the defendant. Defendant, appellant, appellant. Case lordship, the plaintiff is that they have filed this suit lordship, who are the respondent here, for declaration of their right, title, and interest and confirmation of position. It is stated that by Hukumnama lordship in the year 1942, by the ex-landlord, the Maharaja of Ramgarh, they had purchased, they had taken 16 decimals of land. And thereafter lordship, some receipts were given to them. And ultimately lordship in the year 1999, it's very important lordship. In the year 1999 lordship, the lands were mutated. That is their basis of the claim. Several BPLE case was also initiated in their possessed land. Out of 16 decimals, about 3.5 decimals of land also went under BPLE.
This was the case of the plaintiff.
Plaintiff. And
And who are you?
Lordship, we are the defendant number 1 to 11, 14. We are also purchasers of the land by way of registered sale deed. From Lordship, the descendant of the Raja of Maharaja Ramgarh Lordship, namely Indra Jitendra Narayan Singh. And thereafter Lordship, we were in possession. About 1.48 acres land were purchased by us.
Mutation.
Out of total land.
Mutation.
Mutation is not there. It was earlier there Lordship, thereafter it was cancelled.
Earlier means कब तक था?
पहले का था उसका कुछ dispute हुआ उसमें cancel हुआ. Perhaps Lordship, if I am not wrong, I'll just be checking that. The other thing is that the BPLE case which was instituted against the plaintiff Lordship went up to the Honorable High Court. The High Court Lordship, that is also Exhibit G, 7G, wherein Lordship the Honorable High Court has observed that the proper matter was remanded back to the concerned authorities for taking proper recourse and proper decision of the case. That was not done. That is the annexure of the Honorable.
That's it. How does that BPLE proceedings will
Since
happen?
Lordship, we have also raised the ground that since it was not in their possession and because it was a Gair Majurwa land by Hukumnama at that time, since and therefore the government have also claimed that land. Our case is that 1.48.
Government has also filed title suit.
No, they have not filed. It is they have filed a title suit only against us. Since Lordship, their claim is that we entered into their house sometime after purchase of the land. But the purchase is also very back, 1956. After purchase of the land, we have also entered into the house.
So
And
what
therefore,
is your,
some.
what is your point?
My point is that Lordship, since we have purchased from the descendants of the ex-landlord by way of a registered sale deed.
Was the land surrendered? The tenancy cancelled?
What are submitting that? Since Lordship, in the year 1999, they got their land mutated. Prior to that, only some documents are there, which are not government documents. On that basis, somehow they managed to get their land mutated in the year
Your land was
1999.
also never mutated. You never entered. What is the record? What is the position with respect to the record of rights? Whose name is appearing at the record of rights?
Ex-Maharaja landlord Lordship.
Not the name of these
No,
plaintiffs.
not all. Because since it was after the 1942, prior to the preparation of that, the records of right were already prepared. In 1942, by the Hukumnama, it was given to them as their claim is. That is the Sada Hukumnama.
Have they exhibited Jamindari and
Yes, yes, they have.
If they have exhibited that,
They have
the matter
exhibited
should
Lordship.
end
Since that is their Lordship, I cannot go beyond the records.
then that is sufficient. That is sufficient. Hukumnama gets corroborated with that.
But Lordship, the Form M and Form F is also required, Lordship.
No.
Those things are there.
Sarkar
And what they are pleading, they have taken, Lordship. I'm just pointing out that, Lordship. They have admitted that since these things were not done by the ex-landlord and therefore the holder Ram Narayan Singh was himself superior landlord, so he had not felt any necessity, this their case structure, to correct the record of rights. Thus, the land of plot number such and such area 2.5 acres, out of that, Raja has settled 16 disputes of land in the name of plaintiff. Because the Raja wanted his Rayyats, particularly those whose services were necessary for him, and his family to settle nearby in the house of his house, and accordingly the plaintiff has occupied 16 disputes of land with the permission of the ex-landlord. Therefore, the ex-landlord was that was measured through Amin of the ex-landlord, specifying the boundaries, and the Raj Amin, Mr. M. Ahmad, submitted his report on 10/5/1942, specifying the land by plot number 1588 out of 2.57 acres of the land for the consideration of the landlord by Hukumnama under reference number such and such, and granted settlement on the salami of ₹5 and yearly rent of ₹2 Anna. And the plaintiff paid rent to the landlord, granted rent receipts, and also settled several plots, plot number 1588, who are continuing their possession after getting settlement of the said land of the plaintiff. Now, this is the only thing with regard to the possession in other documents.
There is nothing in this. Sada Hukumnama coupled with rent receipt is more than sufficient.
The Jamandai rent receipt also sometimes.
We do not. Exhibit हो गया, mark हो गया, considered हो गया.
हाँ, वो तो हुआ.
तो फिर
But whether that has been properly considered or not, because it is admitted fact, it is a Sada Hukumnama. And they have also admitted because since he was a Maharaja, no one could have said anything to him, and therefore the Amin has given his report, and thereafter they have got the position.
they have been found in possession of the property.
There, since Lordship it is admitted fact. BPLE case, that means they were in possession.
Second appeal number 142 of 2019. Heard the learned counsel appearing on behalf of the appellant. The appellant is a defendant in the suit. This appeal has been filed against judgment dated 11/2/2019, decree signed on 23/2/2019, passed by learned district judge Romanti Hazaribagh, entitled appeal number 60 of 2012, whereby the appeal of the defendant has been dismissed. The judgment of the trial court is dated 4/7/2012, decree signed on 18/7/2012, passed by learned civil judge within bracket Junior Division Hazaribagh, entitled suit number 152 of 1994, whereby the suit filed by the plaintiff has been allowed. The counsel for the appellant has submitted that suit was filed seeking declaration of right, title, interest and possession with respect to the Schedule A property on the basis of Sada Hukumnama, and the genuineness of the Hukumnama was under cloud, inasmuch as in writ petition arising out of a proceeding under Bihar Public Land Enforcement Act, being writ petition being CWJC number 958 of 1985 within bracket R, arising out of Bihar Public Land Enforcement proceeding, the matter was remanded for fresh consideration, but the said case was never decided upon remand. The learned counsel has submitted that the defendants were seeking title over the property by virtue of registered deed executed by the descendants of the ex-landlord. during the course of hearing, it transpired that the claim of the plaintiffs was on the basis of Sada Hukumnama coupled with issuance of Zamindari rent receipt, and so far as the defendants are concerned, though they had registered sale deed in their favor, but the rent receipts were never issued in their favor. The learned counsel submits that the
One thing can be required, Raksha. Paragraph 23 of the update court judgment.
the learned counsel has referred to paragraph 23.
It is in the favor of the respondents also.
Paragraph
23
I'll check.
at page 18 of the update court judgment. GW1 Lordship, who is one of the witnesses of the defendants, he has stated that they are not the defendants are not claiming the land of the respondent. Rather, they are only concerned with their own land which they have purchased through the sale. Because it is a big chunk of land. 2.57 total area is 2.57 acres. We have purchased 1.48, and they are had taken by Hukumnama only 16 dismissals. Therefore, that can also be recorded so that
All right.
things may be clear.
Yes. The learned counsel has submitted that the plaintiffs were claiming only
16 dismissals,
16 decimals of land,
which they acquired through Hukumnama.
which we 16 decimals of land in plot number 1588 in village Padsai, which they claimed through Hukumnama, and the defendants were claiming much larger portion of the land, including the land claimed by the plaintiff. Nahin.
They were claiming 1.48 acres of land out of 2.56 acres of total land of that.
Okay, the defendants were claiming how much?
1.48 acres of land
1.48 acres of land
out of 2.56 acres of land in plot number
out of 2.56 acres of land in plot number 1588.
Lodge.
After hearing the learned counsel appearing on behalf of the applicants, this court finds that altogether six issues were framed by the learned trial court, including the issue as to whether the plaintiff has subsisting title and is in possession over the suit land described in Schedule A. The learned trial court, however, took up issue number 3, 4 and 5 together, and after considering the materials on record, has recorded a finding that in paragraph 28 को कोट करने से ही हो जाएगा ना,
Lodge.
paragraph 28 of the trial court judgment. The learned appellate court has also considered the materials on record and has given concurrent findings. The learned trial court has also in paragraph 23 of the appellate court judgment has discussed the oral evidence of the defendant appellants and recorded that DW1 in his examination in chief had stated that the defendants, according to their same deed, are in possession of the land and have constructed their house. And the learned appellate court recorded that this statement showed that the appellants like defendants are not claiming the land of the plaintiff, rather they are only concerned with their own land which they had purchased through the same deeds. The learned appellate court ultimately recorded the findings in paragraph 32 to 34 as follows and ultimately dismissed the appeal. This court finds that both the learned courts have scrutinized the materials on record and have given concurrent finding with regard to the right title, interest and possession of the plaintiffs. This court is of the view that the order of remand passed by this court in CWDC number 958 of 1985 R dated 31/3/1991 with respect to fresh consideration of BPAB proceeding has no bearing in the present case. This court is also of the view that the evidences produced before the court has been scrutinized. This court is of the view that no question of law, much less any substantial question of law, is involved in the present case. Consequently, this appeal is dismissed. Orders के कुछ cases हैं इसका इससे कोई लेना देना नहीं.
From supplementary for orders item 1, first appeal 86 of 2023.
Yes, how is this first appeal maintainable? यही है क्या?
Yes.
FA number 86 of 2023. The counsel for the appellant on instructions seeks permission to withdraw this first appeal. He has submitted that earlier one first appeal was filed which stood dismissed for default, and therefore he wants to pursue his remedies for restoration of the earlier first appeal. Considering the aforesaid submissions, this first appeal is dismissed as withdrawn. Liberty is reserved with the appellant to pursue his remedy as per the permissible.
उसमें साइन कर दीजिए.
Item 2, ACSB 8 of 2024.
Counterfile.
Yes, Lord, I have filed counter.
Was he heard?
Regarding this, I have to file also reply also.
What are you talking about? Did you hear him? Any hearing was given to him before passing the order? The matter ends. The matter has to be remanded or consequences withdrawn. Yes. Yes, respondents. Other respondents are also there. Madam, whom are you representing?
I am for Jack University.
Jack, you have nothing to say.
And
Or whom are you
I am
representing?
for respondent 6 also.
Whom are you representing?
I am for the state.
State. So I have seen your counter, but I just wanted to know from you that admittedly no hearing was granted to him. So we will remand the matter before the authority. क्या नाम है उनका? Education Tribunal.
Object.
और जो भी order होगा भाई, all the consequences it automatically flows from that. The order has to be set aside.
I have already made a party as respondent number 6 to Amitabh Lordship. As per the notification of Lordship, kindly see Lordship my counter at page 16 also. Can I read also?
Yes.
उपयुक्त विषय के संबंध में अंकित करना है कि सुजीत कुमार उपाध्याय, संस्कृत विभाग, गंगानारायण देव इंटर महाविद्यालय, पूर्वी सिंहभूम के द्वारा कार्यालय को उपलब्ध कराए गए निदेशक माध्यमिक शिक्षा सह संयुक्त सचिव शिक्षा विभाग, बिहार सरकार के पत्रांक संख्या 6066 दिनांक 24/11/1986 के अनुसार स्नातक प्रशिक्षित माना गया है। इसके अनुसार तत्काल प्रभाव प्रचार के रूप
This is
में
on the merits, ना?
Yes,
हम लोग नहीं मेरिट क्रिटिसाइज।
Can we remind it back to us?
I will just remind it back because you are not. He has not been heard.
To give the opportunity to all the parties and thereafter parties to say what.
ACSB 8582 of 2020. Learned Counsel for the parties are present. This appeal has been directed against the order dated 8/7/2024. Para 1 quote करते The Learned Counsel for the appellant has referred to the order dated 3/1/2025, wherein his entire submissions has been recorded. He reiterates those submissions and has further submitted that the counter affidavit filed on behalf of the private respondent also does not reflect that any opportunity of hearing was ever granted to the petitioner before passing the order, impugned in this case. The Learned Counsel submits that the matter be remanded to the Jharkhand Education Tribunal and for fresh consideration so that the petitioner may also be given an opportunity to file his response, and for that purpose the impugned order is satisfied. That's it. The Learned Counsel appearing on behalf of the private respondent has submitted that, has referred to Annexure 6 to the counter affidavit and has submitted that the order has been rightly passed. However, during the course of hearing, he has fairly submitted that so far as opportunity of hearing to the petitioner is concerned, the same was never granted. Correct? The Learned Counsel appearing on behalf of the state and JAC has submitted that the matter be remanded to the Jharkhand Education Tribunal for fresh consideration. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that the order dated 8/7/2024 as contained in Annexure 8 has been passed without granting an opportunity of hearing to the petitioner. Rather, the same was passed without issuing notice to the petitioner.
Yes, my lord, so notice has also.
Same has been passed without issuing notice to the petitioner, and the petitioner was made respondent number 6 in the same proceedings. Consequently, the petitioner has been highly prejudiced, and the counter affidavit filed on behalf of the private respondent also does not reveal about granting of any opportunity to the petitioner. On the aforesaid short point, the impugned order dated 8/7/2024 passed in case number 7 of 2024 within bracket JAT by Jharkhand Education Tribunal is hereby set aside, and the matter is remanded to the same authority for fresh consideration in accordance with law. The petitioner as well as the respondent number 6 shall appear before the same tribunal on, I'll just give a short date. Principal का appointment है क्या है?
And already respondent number 6 has been appointed as a principal. The order has been implemented.
Before the said authority on, I'll just give a very short date within 10 days का कोई date होगा. इसको order permission कराना. Since the materials आपको petition कहाँ है आपका application आपको जो वहाँ फाइल किए थे वो लगाए हैं आप?
No, not. यहाँ पे काउंटर में नहीं।
आपके पास है?
Yes, what, sir?
Counsel for the private respondent has undertaken to provide a copy of the petition which was filed before Jharkhand Education Tribunal to the counsel for the petitioner by tomorrow. एक copy दे देंगे. The petitioner shall also file his on the date of appearance shall file his response to the petition filed by the private respondent before JAP. Considering the nature of dispute involved in this case, it is expected that the Jharkhand Education Tribunal shall take all endeavour to decide the case as expeditiously as possible. The parties to the impugned order has been set aside.
IA has been filed.
आइए close.
IA has been filed during the pendency of the
कुछ
case.
नहीं कर सकते हैं. आ जाने दीजिए, वो ऑटोमेटिकली जो करना होगा हो जाएगा. ऐसे तो आपका केस नहीं डिसाइड हो सकता. वो दाइए दूसरा किस लिए है?
IA was stayed. So the last occasion will be issued.
क्लोज करो. और भी ऑर्डर्स हैं?
From daily list for orders, item 3, first appeal 47 of 2015.
इसमें कुछ रिस्पोंडेंट को नोटिस सर्व नहीं हुआ है. I may be permitted to take fresh steps in present and correct this.
FA number 47 of 2015, the learned counsel for the appellant has submitted that some of the respondents could not be served notice. He prays for how much time?
2 weeks notice.
2 weeks time to take fresh steps. Paper publication के लिए
लास्ट एक बार देख लेते हैं इन present and correct this.
To take fresh steps to the concerned respondents at their present and correct address. Respondent number तो बताइएगा ना. एक substitution भी फाइल हुआ है इसमें. आपको नहीं पता है, आप बस ऐसे ही बोल रहे हैं.
नहीं, हम तो एक ऑफिस नोट्स देख देते हैं नोटिस वाला. आई एम सॉरी, सब्स्टिट्यूशन वाला नहीं देते.
ऐसे नहीं करिए ना आप. ये एक न्यूज़पेपर लगा हुआ है इसमें.
पेपर पब्लिकेशन.
फिर से FA number 47 of 2015, counsel for the appellant submits that he has not been able to go through the records. Post this case on next. ये रिकॉर्ड देखने का काम आपका है. रिकॉर्ड देखिए. एग्जैक्टली बता दीजिएगा किसका क्या करना है.
Item 4, second appeal 264 of 2016.
Yes.
Notices has been issued to respondent of 5 to 7, 17, 18, 19, 19E to J. One of the purpose of the service report is concerned.
आपने देखा है कि नहीं देखा?
हम देख लें. I
देखा,
have
बताइए.
noted down in my
हाँ बताइए.
respondent of 5 to 7 and 17D not found.
5 to 7 and
17D
17D not
not
found.
found. So furthermore, the respondent 18D is concerned notices is hanged since at the time of service of notice 18D is not found on the place of residence.
18D को भी करना पड़ेगा.
Notice hanged on her date.
18C
19A had received by his son Mukesh Kumar and 19EFH to J also received by brother, that is Mukesh Kumar, and 19G died. So इसमें so furthermore the service of notice is concerned 5 to 7 and 17 day. इसमें हम substituted service of notice का तैयार कर रहे हैं. और
SA number 264 of 2016, learned counsel for the appellant prays for time to take appropriate steps for substituted service of notice in connection with respond number 5 to 7 and 17.
17D.
17D.
17. मतलब the 18 का validly sir मान लीजिए since the copy
एक
of
not found है
but the copy has been affixed on the door of the
C और 18D 18D का क्या करें?
18D का ही
Not found है 18D
18
does not reside at the address.
नोटिस लटका दिया गया है वो।
तो कहीं भी जाके लटका देंगे तो क्या मान लेंगे? नोटिस सर्व। इसमें 17D के साथ जो है ना 18C and 18D भी 18C नहीं 18C has been served 18D भी इसमें जोड़ी substituted service
19A EF
19A भी जोड़ी है
ये तो 19A someone has been received by his son Mukesh Kumar
19A
A
कहाँ से बोल रहे हैं? नाइनटीन ए नॉट फाउंड
घर पर नहीं प्रतिवादी 19A तथा घर प्रतिवादी 19E to F G H के नाम का नोटिस हस्ताक्षर उसके भाई ने किया मुकेश कुमार ने। मुकेश कुमार इज आल्सो पार्टी टू द प्रोसीडिंग में 19
देखिए आप जो बोल रहे हैं ना हमारे ऑफिस नोट से टैली नहीं कर रहे। आप इसका चार्ट बनाइए
ठीक है
और उसके बाद जो जो रिसीव किया है जिसका जिसका एक्सेप्ट कराना है आप कर दीजिए और बाकी आपको जो सब्स्टिट्यूटेड सर्विस करना है एक ही बार करेंगे ना नहीं तो पता चले दोबारा पब्लिकेशन करना पड़ेगा। ठीक है ऐसे लिखिए द लर्नेड काउंसिल फॉर द अपीलेंट हैज सबमिटेड दैट has prayed for time to file appropriate petition for substituted service of notice upon respondent number 5 to 7, 17 within bracket D, 18 within bracket D, and he submits that he shall go through the records and may include a few more respondents for the purposes of substituted service agreements. ठीक है आप देख लीजिए इसको कर लीजिए। किसी का डेथ हो गया?
डेथ 19G का
respondent number 19
G
within bracket G has been reported dead. कहाँ पर 19G का
ये
डेथ?
आपको सब्स्टिट्यूशन पिटीशन और मेन एप्लीकेशन में नहीं है। सब्स्टिट्यूशन एप्लीकेशन दैट वाज अलाउड ऑन 16/2/2023 आई नंबर 4453 ऑफ 2020।
भाई पता नहीं हम नहीं जानते ये बहुत अजीब तरह से किसने ये ऑफिस नोट बनाया भाई ये जो बोलते हैं और ये बोलते हैं टैली नहीं करता है और ये इतना जो नोटिस है इनको बोलिए कि भाई टाइप करके करें कैसे हाथ से लिख देते हैं कहीं कुछ घुसा देते हैं कभी ऐसे नहीं करना इस तरह से नहीं करना ये हम उसको पहले कर देते हैं इस ये भी हाथ से लिखा हुआ है। आप ऑफिस नोट से ही देख के बोल रहे हैं सारा?
हाँ
थोड़ा सा एरर हो गया लगता है पुराना ऑफिस नोट।
मैं सबमिट
5 to 7 17D 18D in view of the office note service upon respondent number सुनिए जरा respondent number 19A 19E F E and F then 9H लिखा हुआ है
19H
19H to 19J is accepted as valid. Respondent number 19G has expired. The learned counsel for the appellant has submitted that he shall take appropriate steps for substituted service of notice upon respond number 5 to 7 and 17D who were not found. However, as per the office note, respondent number 17D, 18 with bracket D was also not found. Respondent number 12 कौन appear हुआ है?
12 के तरफ से आपको विनोद कुमार, नेम ऑफ मिस्टर विनोद कुमार दुबे।
उनका नाम टैली नहीं कर रहा है। As per the office note, the execution of respondent number 12 in Vakalatnama does not tally with his name in the memo. The learned counsel who has entered appearance on behalf of respondent number 12 is directed to clarify the position and file an appropriate affidavit with annexing the Aadhaar of respondent number 12. कम से कम आधार तो लगाना चाहिए ना?
But the मतलब the records show मतलब the 1, 3, 4, 8 to 12 and 19. Name of Mr. Vinod Kumar Dubey is there. Respondent number 15 is JN Upadhyay, and again respondent number 11, 8 and 30 Vinod Kumar Dubey.
12 कौन है?
12 Vinod Kumar Dubey है.
अब ठीक है वो एक्सप्लेन करेंगे ना विथ रेस्पेक्ट टू द नेम। नेम गलत हो जाएगा तो सब गड़बड़ हो जाएगा। पोज दिस केस ऑन 5th of March। आप लोग किस लिए बैठे हैं?
Orders item number 5. Next.
क्या हो गया उसमें?
I am for the caveator, respondent number 1.
Who is for the applicant?
Yes, state has referred them. Notice will go to the 16 representatives.
I am appearing for respondent number 1.
FA number 13 of 2024. Learned counsel for the appellant and the respondent number 1 are present.
Okay.
The counsel for the respondent number 7, respondent number 1 has submitted that he has entered caveat. आपको limitation का reply file करना है. He prays for some time to file a petition for a response to the petition for condonation of delay.
They may serve us now.
आप ले लीजिए please.
And notice will go to the remaining.
Let notice be issued to respondent number
2 to 16.
Respondent number 2 to 16 at their under under ordinary process. 2 को आप नहीं represent
Because
करेंगे.
I will take instruction 2 and 3. I can represent their officers of DC.
Yes.
Because I will take instructions. I'll
Let
take
एक
instructions.
second let note 2 to 16 कर ही दीजिए. For which requisites under ordinary process be filed within a period of 10 days. Admit नहीं हुआ.
नहीं.
In the limitation petition also.
Yes.
In the main appeal as well as IA number 11409 of 2024. In the meantime, let the records be called from the concerned court. Let this order be communicated through fax. Post on 5th of March. ये लिमिटेशन अभी कंडोन बिना किए एडमिट नहीं करेंगे. रिकॉर्ड मंगा लेने हैं सर.